G'day, it's fugitive Australian journalist Shane Dowling from the website kangaroocourtofaustralia.com. Now, an alleged Queensland sex offender has been granted interim suppression orders, stopping them from being named, which is clearly designed to override the new laws that are coming into effect next Tuesday, the 3rd of October 2023, whereby sex offenders who have been charged but they haven't had it set down for hearing can't be named. That law has been around since the 1970s in Queensland, but it's about to change next week, next Tuesday, whereby if someone's charged with sex offenders, you'll be able to name them like you can name anyone else who's been charged with criminal offences. But this alleged sex offender went to court on Wednesday, the 27th of September, and was granted interim suppression orders. I'm going to read them out to you in a second, saying they can't be named. It's my understanding that this is the second time this alleged sex offender has applied for suppression orders in the last couple of weeks. Now, it has nothing to do with the Toowoomba case, not the person or anything. So it's not that person, but this is a sex offender trying to override or bypass or circumvent the new Queensland laws that come effect next Tuesday. And it even says it in the court orders. So I'll read out the court orders to you. Now, it says at the top of the court orders, in the Magistrates Court of Queensland, an application for orders under the Criminal Law Sexual Offences Act 1978 by XYZ. XYZ is a person. Then orders are made by a magistrate on the 27th of September. And application filed by the defendant with leave on the 27th of September. Now, it says the order of the court is that, number one, the application be made returnable immediately. It sounds like they went to court ex parte by themselves and said, we've got an urgent application here, Your Honour. And they were granted that by the sounds. Now, court order number two. Pursuant to Section 7D of the Criminal Law Sexual Offences Act 1978, the publication of identifying matter relating to XYZ, that's a person, as a person charged with a prescribed sexual offence is prohibited. So that's court order 2. Now, court order 3 relates to court order 2. Court order 3 says operation of the order in paragraph 2, which is order 2, be suspended until the commencement of Part 9 of the Justice and Other Legislation Amendment Act 2023. So court order 3 is saying court order 2 is suspended, and it only comes into effect when the new laws in Queensland come into effect, which is next Tuesday, saying that you can name these people charged with sexual offences. Court order 4, court order 4 doesn't really matter, it's just the affidavit of XYZ, filed with leave, and any exhibits is to be placed in a sealed envelope and marked not to be opened without an order of the magistrate. Court order 5, that's interesting because it just confirms why these orders have been made. They're being made to override the new laws coming into effect next week. Court order 5 says the application otherwise be adjourned to not before 11:30am on the 3rd of October 2023 for mention. Mention is the directions hearing. So court order 5 in effect confirms that it's there to override the new laws. That's the purpose of this suppression order. Now, the magistrate, I believe, shouldn't have issued these interim suppression orders because they're only issued until the full hearing can be had in relation to the suppression orders. And there's no date set. He could have set a date even. Now, I should say him or her because I don't know if the magistrate was male or female, but I don't believe they should have issued the orders. Apparently, this is a second attempt by that person in the last couple of weeks, which is very disturbing if that is the case. And the magistrate had to be they were aware that new laws were coming into effect next week, and the magistrate knows this suppression order application is there to override that. They should have, if they're going to allow that person to have an urgent hearing for interim suppression orders, they should have set down the hearing for the full suppression orders for next Tuesday on the day. Why not? But they've only set it down for mention, which they know full well that's going to allow that person at least a couple of weeks probably to have suppression orders that they potentially weren't entitled to in the first place. Now, I followed up with the Attorney General's Department seeking comment on this matter. And the reason I know about this matter is because the lawyers actually sent me a letter with the court orders in it. So, and they actually named that person. So they were actually in breach of the court orders themselves when they're sending me a court order and a letter naming that person. Now, I'll keep on following up on the matter and see what happens. And Kangaroo Court of Australia is independent media. I publish a website and a YouTube channel, and I'm 100% crowdfunded from viewers like yourself. So please support my Patreon account and please share this video on social media. Thank you for your time and have a good day.